Good afternoon, everyone. This is Rebecca Smith-Aldridge from the Mid-Hudson Library System, and we're pleased to have you here today for the Fair Labor Standards Act and New Overtimes Rule webinar with Sherry Constantino and Kim Swarthwout from the Cornell University. We think it's a pretty timely time for us to be having this conversation and learning more about this issue, and Sherry is here providing this information with a very clear caveat that everything she's saying is time sensitive. So we encourage you to make notes throughout the event today, noting which things might change as time moves on. I'm sure she'll point out what those things are as well. Today we've got everyone on mute to cut down on background noise, so please use the chat box to ask your questions. Sherry said she'll stop every once in a while to take questions, and I will moderate those on your behalf. So please feel free to add your questions into the chat box as they occur to you, and I will keep track of those. So Sherry, I'm not going to attempt to do the acronym, so I'll let you introduce yourself and Kim, and I'll go ahead and hand that over to you. Thanks so much for being here today.
Sure, it's our pleasure. I am Sherry Constantino, and the acronym PHR just means that we are certified as professional in human resources through the Society for Human Resource Management. Kim and I both got our certification years ago, and we have both been working in compensation for close to 20 years, and that whole time we've pretty much worked together. So, and the Fair Labor Standards Act is something that we are responsible for on a daily basis. So hopefully I can answer all your questions, and I will also, with the caveat that some of your libraries are probably considered local government or a municipality, and that is something we ask that you contact your attorney about and get clarification. It looks like someone's having trouble hearing me.
Sherry, don't worry about it. I'll handle that.
Okay, so we're going to go forward. So the Fair Labor Standards Act is also referred to as the Wage and Hour Law, so you'll hear it go back and forth. And it regulates employee status, so who can be paid, what's considered an employee, and who can be paid by an hour, and who can be paid by a salary. It does give you child labor laws, the minimum wage for both hourly and salaried, overtime pay, and record keeping. So New York State's a little bit different. We're 6 years after termination, and that's because we also have the Wage Theft Prevention Act that came out, I believe, somewhere around 2010. So what the Fair Labor Standards Act does first is it distinguishes between employee, what is employee status, and independent contractor status. If you have independent contractors working for you, you have no FLSA obligations. Now, to be an independent contractor, and this is where the Department of Labor loves to get people on violations. An independent contractor, there's some criteria. They have to control their own hours. You can give them the project, but they control their own hours. They use their own tools and resources and supplies. And you can give them a deadline, but how they get it done, where they get it done, is strictly up to them, and it's not something the employer can control. So a lot of people try to hire as independent contractors, and that's where we get into a lot of trouble. So the FLSA exemptions start with, there's 3 criteria that an employer has to meet for an employee to be exempt. There's a minimum exempt salary, which we will talk about. It keeps fluctuating right now, given everything that's going on. It has to be paid on a salary basis without improper deductions, and you have to perform exempt duties. So currently, right now, you are an exempt employee is guaranteed overtime protection, you're guaranteed overtime protection to employees who earn less than, for federal, it's $23,600 per year, or $450 per week. New York State is always higher. When they increase their hourly minimums, they always increase the exempt minimum as well. And we are at $675 per week, which is $35,100 a year. As we all know, as of December 1st, the federal government was going to increase the exempt minimum to $913 a week, which was $47,476. This has been postponed. Several agencies and employers filed a lawsuit in Texas, actually, and the Texas Federal Supreme Court there postponed the implementation of this. And however, they also just granted the Department of Labor an expedited appeal, which means they have until, I believe it's January 16th or 17th, to get their briefing. And hopefully that the federal court in Texas will rule by the end of January, beginning of February, on whether or not we all have to follow the 913 a week. And they may even say you have so many more days to comply. So right now the 913 a week is on hold. However, New York State has come out with their exemption salary threshold that's going to increase every year right now until 2020. I do have that in these slides, so I'll share it with you in a moment. And they just closed the comment period on December 3rd, I believe, so any day now we're waiting to see when that's going to be implemented. And since they increased the hourly wage on December 31st, chances are the exempt wage will go up at the same time. We're just waiting to hear word on New York State. So the one big, I think, change for some is there are no exceptions or proration of the we'll use $675 for now, of $675 a week for part-time exempt work. If you work 20 hours a week and you're exempt, you have to be paid at least the $675. If you work 40 hours, 15 hours, whatever it is, it's regardless of hours worked, to be exempt and be considered salary, it has to be $675 per week. And as you can see, what's also on hold and postponed is the automatic updates every 3 years on the federal level. Right now, that was also postponed, and they said it was outside the Department of Labor's authority to say that they could increase it every 3 years. So right now, as soon as we hear anything, I promise to forward information on to Rebecca on that. Are there any questions so far?
None have come through yet, Sherry.
Okay, great. So it's really confusing with the postponement and what's going to happen as we move forward.
Oh, actually, Sherry, we do have one. We have a very basic question of what does exempt mean?
We're going to go into that right now. Can I hold off on that question? And if I don't answer it here, I'll answer it in a minute?
Sure.
Okay. Part of what it means to be exempt is it's a primary duty. It's your most important duty that you perform on a daily, weekly basis. It includes the exercise of discretion and independent judgment in matters of significant, and that's the level of importance or consequence of the work performed. Now there's 3 tests to be exempt, and you can fall in one of the, well, there's 3 main ones, and then there's a couple others we'll discuss. The first one is the executive exemption. So in order to be exempted under the executive exemption, we'll get to that in a minute. I just saw that question. I'll show you a chart of how it's going to increase from starting in December 31st, 2016 until December 31st of 2020. So to meet the executive exemption, you have to manage an enterprise, department, or subdivision, direct the work of at least 2 or more full-time employees. But this could also mean you could have 4 part-time employees. But however you get the 2 or more full-time employees, it will fall under that exemption. You have to have the authority to hire and fire, affect promotion decisions, make salary decisions, and also the authority for disciplinary actions. So if you meet all these requirements, you could be considered exempt, and you make the $675 a week.
Sherry, when you say exempt, just to clarify for that first question, you're meaning that they are exempt from the overtime rule?
Yes, salaried employees.
Right.
They do not have to earn time and a half after 40.
There we go. Thanks.
Does that make more sense?
I think that's what the person was looking for, yep.
Yep. So exempt means if you can work 40 plus hours and not have to be paid time and a half after 40, but you have to meet the salary requirements and the duties tests. There's also the administrative exemption. This is probably one of the most popular, and your primary duty involves office or non-manual work directly related to the management or general operations of your business. And it also has to include the exercise of discretion and independent judgment with matters of significance. And this just means, for example, HR falls under this. It is always 40 hours per week for time and a half. So if you work 35, you get 5 hours where someone else can work, and it does not have to be time and a half. Under the administrative exemption, it's positions like accountants and human resources and financial analysts. It's where they can make a decision without having to go back to a supervisor and say, is this okay? I mean, sometimes you have to do that, but you have some judgment to make a decision and take some risk with what you're doing. Basically, that's what the exercise of discretion and independent judgment means. So if you meet this requirement and the salary requirement, you can also be determined to be exempt from the overtime. So then there's the professional exemption, which is not used as much, and there's two parts to this. You can either fall under the learned professionals, where it requires an advanced knowledge in a field of science or learning and is acquired by prolonged instruction, and it's intellectual in nature and requires the exercise of discretion and independent judgment. What this means is it's jobs like research associates or lawyers, doctors. You cannot become a lawyer or a doctor or even a research associate requiring a PhD without going to school. So it's not something, you cannot be exempted under this in a position where you could be working in it for 25 years and you've learned it along the way. You need that advanced knowledge and the advanced degree. The other piece of the professional exemption is you can be a creative professional. This must meet the minimum salary requirement, and you have a primary duty that requires invention, imagination, originality, or talent, and it has to be in a recognized field of creative artistic development. So what could fall under here are graphic designers, web designers, where you're doing all original work. Someone's not saying, I need a box with this word in it. It's all original and imaginative. One of the examples they use is a photographer for National Geographic. That's considered a creative or artistic field. It's recognized and it requires imagination and talent to do that type of work. So you don't see a lot of exemptions in this realm. And currently, this is the only exemption, professional, learned and creative, that only has to meet the federal minimum of $4.55 a week. New York State did not increase the minimum for this one. So it's a little bit different here. However, if the Federal Court of Appeals says that the Department of Labor can move forward with their increase to $9.13 a week, they have attached it to the professional exemption, so we just have to watch for that. There is an exemption for computer employees. So, you must meet the salary minimum of $4.55 or $27.63 per year, which is about $56,000 a year. You must have duties that consist of the applications of systems analysis, design, development, and creation of code, so programming code, or the design documentation, testing, modification of computer programs. What you cannot be under this exemption, and which is now a non-exempt job, is those that are engaged in the manufacture of repair of the computer hardware and the equipment, and it's facilitated by the use of the software programs that's not involved in programming. These would be your desktop support, your help desk positions. There was a lawsuit probably now 10, 15 years ago where IBM had all of their desktop help desk support as exempt, and they were sued by employees, and they were all owed back overtime pay over 40 hours, and it was tens of millions of dollars. So I know that back in 2004, when this exemption became more clear, we converted most of ours to non-exempt. So this is another one that the Department of Labor likes to look at. So those are the 4 main exemptions that you would probably use in the library system. There is an outside sales exemption that we typically don't talk about because most of our customers don't have outside sales, and it's a pretty rare exemption to be used now, and not many people have them. So we do leave that one off, but if you'd like information on that, I can absolutely move it forward. So are there any questions so far about the 4 exemptions we've talked about? No? Okay. So one of the parts of the Fair Labor Standards Act is you're paid a salary and you cannot have improper deductions take. So if you do take improper deductions, say someone goes to a doctor's appointment for 2 hours, you cannot deduct a salaried employee's paycheck for those 2 hours. Because under the Fair Labor Standards Act to be exempt, it's not the hours you work, it's the work being done and the quality of work and the complexity of the work. So if you deduct those 2 hours for that doctor appointment, you've lost your exemption. So the only way to deduct from an exempt salaried employee is in full day increments. They do allow half-day increments, and you can substitute with banked time, so your sick, vacation, personal. And the only exception to that is the Family Medical Leave Act. There is a safe harbor if you do improperly deduct, say for that 2 hours of doctor's appointment. The employer has to have a clearly communicated policy prohibiting improper pay deductions. You reimburse the employee for the improper deductions, and you make a good faith effort to comply in the future. So if you deduct from someone and they call the Department of Labor and file a violation, as long as you take these steps, the reimbursement, you promise to make a good faith effort, and you have the clearly communicated policy, chances are they'll just say, okay, you made good, you reimbursed them, please just don't do it again. When there's willful, intentional violations is usually where the Department of Labor starts handing out high fines and back pay, and they start digging deeper. So this is your safe harbor if you accidentally make improper deductions. So here's your chart of what New York State looks like. I did ask Rebecca if there's anyone outside of the Mid-Hudson region down closer to New York City, because it looks a little bit different once you start hitting Suffolk County, Nassau County, and Westchester and things like that. So currently for New York State, as we all know, our hourly minimum is going to go up starting December 31st to $9.70, and it increases about 70 cents a year until 2020, and it hits $12.50. The New York State exempt minimum, which we're still waiting to hear word on, but it's looking pretty good that it'll go through. Currently, it is $6.75 a week. That will go to $727.50 and increase every year after that until 2020, when actually it'll be higher than the federal minimum if the 913 goes through. Ours will be $937.50. This is something to watch. It starts to get very expensive. I know the $727.50 is the equivalent of $38,740 a year, and it cannot be prorated for part-time. So this is what the minimums, the hourly minimums are definitely already signed into law, and this is what it looks like the exempt ones will be, as long as you're in the greater New York State area. And New York, like I said, New York City looks a little bit different. Any questions so far? So the basic overtime provisions that are set by the Fair Labor Standards Act is an overtime rate of 1.5 times your regular pay. And it's on time worked, not compensated. So if you have an employee that worked 40 hours and has 8 hours of vacation also, so they're being paid for 48 hours, all of that is straight time. You do not have to pay time and a half on the 8 hours of vacation. So it's only on time worked. So whatever payroll you use, they should know that and be looking at that. And the FLSA also says that you have to have a set fixed work week. And it has to be a recurring period of 168 hours. So ours happens to be Thursday through Wednesday. You can do Sunday to Saturday. It doesn't matter what the 7 days are, but it has to be fixed and set and cannot fluctuate to sort of avoid overtime. And I would highly recommend that it's written down in an employee manual somewhere so all employees know what your fixed work week is. So for compensatory time, this one gets a little complicated depending if you're considered a local government or a municipality. You can allow compensation time and they can accrue it. So it can be kept in a spreadsheet or on a napkin or however you do it. For everyone else, compensatory time is not allowed. It has to be paid out in cash or your paycheck. If it's over 40 hours, time and a half. And what you can do is move to a flexible work week, saying if someone came in, worked 4 hours late on a Tuesday night, they can come in 4 hours late, say on Wednesday, so there is no overtime. If you're not a public sector employer, a local government agency or municipality, compensatory time must be dealt with within that work week and cannot be accumulated. This is another place where a lot of employers get in trouble. I know we've had a case over the years where a temporary employee over the summer kept a spreadsheet and accumulated 400 and some hours of comp time, called the Department of Labor, they came in, and we had to pay out 400 and some hours of time and a half overtime pay comp time. So it is not allowed for anyone but local governments and municipalities. We have a scenario. See, your department is going through a budget crisis. You specifically tell your staff no overtime. However, you learn despite your instructions, Lisa has been working through her lunch and her time card shows she has worked 45 hours this week. Do you have to pay her overtime? You must pay the overtime. Although you gave the instructions, a policy might say that no overtime is allowed without prior, without them telling you that you can work it. You are legally obligated to pay it. You are legally obligated to pay that 5 hours of overtime, and then you can proceed, and it sounds horrible, but the way you can proceed is through disciplinary action, having conversations, but anytime an employee works overtime, even if the supervisor says no overtime, it must be paid out. So I just saw a question about part-time employees. What is there an exact? So a part-time employee is anyone typically less than 30 hours work a week, and if you're salaried, exempted from overtime, regardless of your hours, you have to be paid that exempt weekly minimum. Does that answer your question? If it doesn't, let me know. Volunteering time. Oh, great. Okay. For volunteering time, this is another place where employers get in a lot of trouble and the Department of Labor likes to come in. So employees may not volunteer services to for-profit private sector employers. So I cannot go and volunteer my time at, say, Walmart. Okay, Walmart has to pay me. Individuals can volunteer to public sector employers and or nonprofit employers. That's fine, as long as I do not work there. So if I am a nonprofit or public sector employer, I cannot allow my employees to volunteer without compensation to do the same work for which they're employed. And that's a pretty broad sweep. So even if my job is to shelve the books, if I wanted to volunteer 5 hours a week at the front desk for people to take their lunches, I have to be paid for it because you cannot volunteer as your employer to do work of which could fall under your normal duties. There is no prohibition on anyone in the private sector volunteering in the public sector. And again, this is as long as you do not work for that public sector employer. For those of you in libraries and maybe you have a local parade for Halloween or something like that, and you carry a banner. If you work for that library, you cannot volunteer to carry that banner. That would be, you would have to be paid for that time. There's a lot of risk in that, and this is one of the places where the Department of Labor does find a lot of violations. So next we'll cover what hours are considered worked under the FLSA. It's under the Portal to Portal Act, so it's travel time, waiting time, on call, rest and meal periods, lectures, meetings, and training programs, another place where they typically find violations. The first one, we'll do travel time. This one, again, gets a little confusing at times. So on an ordinary workday, obviously to and from work, it's not paid time. Okay, so those of us, we get up, we drive to work, then, our day is over and we drive home. That's all not paid. However, if you have multiple job sites and someone has to travel there in the middle of their workday, that is obviously paid time. Okay, that's not a lunch, it's not a break time, that is all paid time. For one day, travel time for one day business, the rules are a little bit different. Time involved in one-day travel, which is over and above ordinary commuting travel time for the employer's benefit, count as hours worked. So if I have a conference in Rochester and my normal workday starts at 8, but I have to leave at 6 a.m. and I'm an hourly employee, the clock starts ticking at 6 a.m. It's over and above your normal travel, and the conference is for the employer's benefit. And same traveling home. If my workday ends at 5 and the conference ends at 4 and it takes 3 hours to get home, those 2 hours between 5 and 7 are paid time. Travel away involving an overnight stay. This is where it gets a little bit more tricky, and this is all for hourly employees. So if it keeps you away from home overnight, travel away from home is clearly hours worked when it takes place during the regular scheduled hours. So if I get on a plane on a Monday at noon and I fly down to New York City, that is all paid time because it's during my regular business hours, and I'm just substituting the travel for other duties. Now, if your employee is scheduled to work 8 to 5, Monday through Friday, and travel time on a train, bus, plane, automobile during these hours is worked on a Saturday and a Sunday, that is paid time. Anything outside of those hours, time spent traveling as a driver, is compensable work time, but not as a passenger on the airplane, bus, or train, boat, or if you're a passenger in the same car. However, with that being said, if you are a passenger in any of those capacities, if you do any work, make a phone call, send an email, write a brief, write up a programmatic thing, that is all time paid. So you've got to be really careful with hourly employees if they travel overnight. If they sit in their hotel room at 8 o'clock at night and they send out 2 hours worth of emails, that is all time paid. Okay. The travel time's a little tricky for hourly employees. Are there any questions at this point? Okay. So waiting time. This is another tricky one where people typically in violation. It's counted as hours worked when you're engaged to be waiting. And this means that the employee is unable to use their time as their own. So you have controls where they can go, how far away they can go, and if they get a phone call, how quickly they need to be back. So take a help desk support person that's on call for the weekend. If you get a call, you need to be within 5 miles of the employer to get back to fix the problem, you have now engaged them to be waiting, and all that time that they're on call is hours paid. It doesn't count as hours worked when they're waiting to be engaged, which means they're completely relieved of their duties. They can drive an hour away and do what they need to do. You have not restricted their movement or the time, and you have not limited them to miles away or minutes back to the employer. So those two things, engaged to be waiting and waiting to be engaged, can be a little confusing. But the biggest thing when hours have to be paid is when you restrict their movement and they cannot use their personal time as their own. There's an example down here of a secretary who reads a book while waiting for a dictation, or a fireman who plays checkers while waiting for an alarm is working during such periods of inactivity. Those employees have engaged to be waiting, and it's all time paid. On call, it's hours worked when the employee has to stay on the premises, or they have to stay so close that, again, they cannot use their time as their own. It's on-call time is hours not worked and not paid if they're just required to carry a cell phone. You know, they can leave word at home, or, you know, you can just pick up the cell phone and the employer pays for it. And they can handle the problem over the phone or say, okay, I'll be there in a couple hours and I'll fix it. As long as you're not putting constraints on their freedom, it does not have to be compensated. So each situation will be different, and you'll have to evaluate each situation. If you have human resources, they're a good resource. If you don't, there are some fact sheets on the Department of Labor's website. I can send them to Rebecca for you, or you can contact your attorney if you have one. Rest and meal periods, usually 20 minutes or less is paid as working time. So if someone works 4 hours and gets a 15-minute break, that's paid time. If they have an unauthorized extension and they take 30 minutes, you don't have to pay them for the 15 extra minutes they took. And again, then you turn it into disciplinary action if it warrants it. Bona fide meal periods, 30 minutes or more, which is typically, I think, 6 hours, you have to start giving an unpaid 30-minute break. They do not have to be compensated as time worked. However, the employee must be completely relieved of duties. They're sitting at their desk and they might pick up the phone or answer an email. That is not being completely relieved of their duties, and that 30 minutes becomes paid time. So this is very important for non-exempt employees, and it's tough if you have, even if you have an employee lounge they can go to or a cafeteria, and they sit in there and they're looking at their phone answering emails, or even having a work discussion with a fellow colleague, that can turn it into paid time. So it's really important that they're completely relieved from their duties, and try not to have them sit at their desk during their lunch or dinner time. For training and seminars, you do not have to pay employees unless all of the following criteria are met. So the attendance is outside your regular working hours, it's voluntary, it's not directly related to the employee's job, and they do not perform any productive work during the attendance. Most of us who attend these trainings and meetings or conferences, it is usually always directly related to your job. So most of the time, I'd say 99% of the time, attending trainings and seminars, even if on a weekend, would be paid time. So typical problems where the Department of Labor likes to come in is when employers fail to recognize and count certain hours as work as compensable. One of the things that, to be honest, that we have gotten in trouble for here at Cornell is the lunch hours. where employees sit at their desk and eat, and they'll answer the phone, or they will sit in the lunch break room and answer emails on their cell phone, or make that phone call that they just didn't have time to do during the regular hours, not on a break. And that's a work phone call, not personal. That is where a lot of employers get in trouble, and the Department of Labor comes in, and overtime starts to kick in, and it gets very expensive. There are employers who have been in trouble for telling people to not clock overtime. I know you stayed an extra hour, but please don't put it on your time card, and we'll figure out another hour where you can leave early. That is illegal. That's a huge violation. It is intentional. And with the Wage Theft Prevention Act, they can now go back 6 years and look at the employee's time and give 6 years of back overtime pay, apply fines to the organization, and now not only that, but if it goes to court, the employer would be responsible for the lawyer's fees for both themselves and the employee. So it gets very, very expensive for willful, intentional violations of the Fair Labor Standards Act. So it's hard sometimes with coverage to find people's time, completely relieve them of duties, but if you cannot, then I would consider it time paid and just pay that time out. So record keeping, the FLSA requires all employers to keep and preserve certain records. It's an accurate record of hours worked each day, the total hours worked in each week. This is critical to avoid compliance problems. They don't have to be kept in any kind of form. They can be on a napkin. They can be on the back of a piece of paper. Most of us now have either formal paper timesheets or electronic timekeeping systems, so it's not a problem. If an employee files a violation on you and the Department of Labor comes in, you will speak to you. They will ask you certain questions, but they will always take the employee's word above yours. So if an employee says, oh yeah, I typically work 10 hours of overtime a week and I've been doing it for the last 8 years, the Department of Labor will believe them. And unless you have proof otherwise, that is where they will start their calculations. They will go back to the 6-year mark and they will calculate 10 hours of overtime per week for the last 6 years. So it's really important to keep those records somewhere. And those records have to be kept for at least, I believe, 6 years after termination of the employee. Sometimes people will recommend maybe 10 years just to play it safe. So it does say each employer preserve for at least 3 years payroll records, collective bargaining agreements, sales and purchase records, 2 years time cards, piecework tickets, wage rate tables. And this is after the termination of an employee. Wage theft prevention, I believe, says 6, and we highly recommend the 6 because you never know when someone will file a violation. I know that we fought a DOL, an FLSA violation, where the employee was actually clearly exempt. Maybe not have, did his exempt work during the day, but filed a violation on us, and it took us 10 years to fight it. We eventually won, but it was stacks and stacks of paperwork and many years and many hours, man-hours to fight that one violation. So it's really important. I would recommend the 6 years if you have the space to, after termination of an employee. Yep. That is the end of the presentation. I feel like we went through that rather quickly. Does anyone have any questions? Okay. I didn't see that whole question, Rebecca. Let me see.
Sure.
Regarding.
Let me read it to you. Regarding the sick time for exempt employees, if someone has a doctor's appointment during work hours, those hours cannot be deducted from the accrued sick time. Only full days can be deducted from accrued sick time?
Yes, only half days or full or full days. They do allow half days if you have banked time. So if you have the personal vacation sick. So for a salaried employee, an exempt employee, a couple hours here and there for doctor's appointments, you cannot deduct unless they're under the Family Medical Leave Act. So if you go to a doctor's appointment for 2 hours, you don't have any FML paperwork done. That 2 hours is just 2 hours. The employer sort of has to eat it because they say that although they should work 40, it's about the quality and complexity of the work being done, not necessarily the time it takes you to do the work. Does that help? Okay. Any other questions? I can send this presentation to Rebecca. In fact, I will, because it does have the wage chart in it. As New York State, we're waiting to hear from New York State. I will keep Rebecca also updated on what the Federal Court of Appeals does down in Texas on the federal FLSA exempt minimum increasing. So regarding lunch periods, if an employee works a 5-hour shift, is a 30-minute lunch period needed? I believe 5 hours is 20 minutes of paid time. So I think once the 30-minute lunch period or dinner period, however your hours are set up, kicks in at 6 hours. So if it's 5 hours, 5-hour shift, 9:30 to 2:30, they would need a 20-minute break between, I believe it's 11 and 1, 11 and 1 or 11 and 2. 11 and 2. So there's specific hours they have to take the 20-minute break. But yeah, it's just 20 minutes. It would be paid time. Can you say that one more time? Do they use accrued time off for a few hours? No. Unless they took a half a day, so if they work 8 hours a day and they took 4 hours, it cannot be deducted. They can use their banked time for 4 hours or more. So if they went to the doctor's for 3 hours, it's 3 hours that cannot really be deducted without using the exemption, even in banked time. It's half day or full day increments. Now, on the other side of that, the employer can speak to the employee if it's being misused. If all of a sudden someone has a doctor's appointment every week for 3 hours and they're not taking any time and they're not getting their work done, that's a disciplinary issue. If library only has 2 employees, the director can't be exempt no matter how much they earn. Sure, it depends on the duties. So if the director of the library, so the director of the library, what he or she would not be is exempted under the executive.
Sherry, we didn't see that question. Can you read the question for us?
Oh, sure. It's from John, and it says, if library only has 2 employees, the director can't be exempt no matter how much they earn. And yes, they can still be exempt. They just would be exempted under the executive exemption. You would move to the administrative exemption. And a director of a library would definitely fit under that. And then they would have to meet the $675 a week. Yeah, so they can be exempt. It just, you wouldn't be able to use the executive exemption. So then you just move to your next exemption, which would be administrative, that they would fall under. So when you're looking at someone's duties, the tests are there to determine which one they fall under. So if you read the executive and they don't have the 2 or more full-time, employees, however you work that out, then you just move over to the administrative, and do they fit that? Yeah, that's definitely office non-manual work directly related to the business and the customers, and they definitely have the independent judgment and discretion to be exempt. So, now you just have to look at your salary test of $675. I hope I didn't miss any other questions. That one just popped up real quick and I just caught it.
I don't see any other questions coming through.
Okay. Great.
All right. Well, Sherry, I guess we'll call it closed then. If we see no questions coming through, it sounds like you're going to send us the slides. And
Yes.
I know Eli had given me a couple of the sheets from the Department of Labor that you recommended we share also. So I'll send that on to everybody who's registered for the workshop.
Okay.
Sherry, I just want to say thank you so much for everyone who's on the call today to realize Sherry is volunteering her time to do this webinar for us, which I think is just fabulous. This is the kind of stuff that we're just not born knowing, and we certainly don't learn in library school. So, Sherry, thank you so much for taking the time to speak with us and sharing your expertise.
Sure, and I will keep you updated on anything I hear, as we move forward with the lawsuit.
Thank you so much.
You're welcome. Thank you.